encouragement and guidance in getting through that process. So this brings me to Kay, a wonderful, hard-working EMT, much like RC, good, hard-working family people that we are so appreciative of the opportunity to work with. Kay, again, an EMT, was involved in a minor impact wreck with a franchise restaurant delivery driver that we were able to establish was actually working in the line and scope of his employment. In other words, out making food deliveries, and caused the wreck, again, while in the line and scope of his employment. And that was so important for us to be able to establish and prove, even though we had to litigate that issue. It was a contested issue. A lot of these delivery providers have software programs that keep track of hours and locations and try to determine, is this in the line and scope? And they were trying to use that, but we had solid testimony to be able to prove the driver was in the line and scope of his employment. But again, it was a contested, disputed, litigated issue that we had to prove. At the time of our initial consultation, Kay had just started a new job, so she didn't have medical insurance at the time, but was still complaining of shoulder pain and a nagging popping. And again, these cases can take time to litigate, and without the benefit of health insurance, getting that follow-up treatment and care can be very challenging. Fortunately, we were able to help navigate Kay through her follow-up treatment, helping her get it scheduled and coordinated and covered on her newly established medical insurance plan. And it turns out she was actually suffering from a torn labrum, which is a reoccurring injury that we're actually seeing more and more in automobile wreck cases. Again, this prompted us to file a lawsuit and obtain the insurance policy limits from the delivery driver, along with a confidential settlement from the restaurant franchise and a UIM settlement. Wanton conduct is another area. Another way to think about it is reckless conduct, but under injury law, it's more often described as wanton conduct. But again, a good way to think about it is reckless conduct can drive value with the potential to recover punitive damages. And with punitive damages, unfortunately, to many people that are injured in automobile wreck cases, Alabama has some very harsh and unfair laws that really treat the injured oftentimes unfairly in the court system. One of those is contributory negligence. And under contributory negligence, if you're deemed 1% at fault, that can be a complete bar to recovery, which is just another reason you need to be protected. You need to work with an experienced automobile wreck lawyer, an experienced injury lawyer that can, again, help you navigate through this process. But one of the benefits of if we can uncover reckless, wanton type conduct, that brings in the potential to recover punitive damages. And in that punitive count or that punitive case, we're able to avoid contributory negligence. So that can drive value in the case. In fact, if the tortfeasor is intoxicated, we must go further and investigate the facts and circumstances around that intoxication. In other words, where was he served at? And pursue a dram shop case and again hold everyone that's involved in causing the injuries and damages, hold them accountable. Now, this brings to mind, and this will shed some light and give an example of a dram shop case. I recall Jay, who was a hard-working college student and soldier, that was seriously injured in a motorcycle wreck at the hands of a drunk driver that literally got tanked up at a local bar and fled the scene after seriously injuring this young student soldier, causing him to need operations. When I arrived, I was glad to be able to go over to the home and visit with his family in their kitchen, at their kitchen table, spend some time with them, getting to know them, again, encouraging them, offering hope and support and guidance in this very difficult situation. When I arrived there, desperation and kind of a loss of hope, I like to think it just seemed like they had lost hope, and it was almost like, again, like desperation had set in. They were under the impression that there was no chance of any type of successful legal action, or to be able to hold anyone accountable under the circumstances. Because at that point in time, the identity of the drunk driver was unknown. He had fled the scene. Again, leaving this young man on the side of the road after clipping him and running into him, running him off the road, just kind of leaving him there to be picked up by the ambulance and rushed to the hospital to have surgery. And again, it was another motorcycle wreck. So again, the identity of the drunk driver was unknown at that point, but with the assistance of an investigator that we brought into the case, we were able to conduct our own investigation, connect the dots, locate vehicles and evidence, and ultimately determine who the driver was. Obtain some police reports and just various items of evidence that we were able to, again, connect the dots, which led to an insurance policy limit settlement from the drunk driver. But we didn't stop there. We did something that had not even occurred to the family. We first researched any underinsured motorist coverage available, and we next pursued the bar that served this drunk driver. Now you may think, well, what about accountability? It was the drunk driver that caused the wreck. Well, this is quite possibly just one of the best set of facts in a dram shop case that we've ever encountered.